There are growing concerns that territorial claims in Southeast Asia is turning the area into an international flashpoint. Why then are some parties reluctant to seek third-party mediation?
No two countries would look at and approach a subject in the same way. And this is also true in the West Philippine Sea or the South China Sea, that all the countries looked at it differently. And so far as the Philippines is concerned, we respect their views and approaches, but in our case, we believe that the peaceful approach that is suitable under our particular circumstances, given our particular priorities and our appreciation and evaluation of the situation, is that arbitration is the way to go forward.
Well, when it comes to third-party mediation with regard to claims involving sovereignty and sovereign claims, a party has to see its own national interest as being able to be treated in such a forum. And what you really require then is, particularly vis-a-vis the other party, is a relationship of trust, the idea or the belief that your interests will be well served if you go to such a forum, and again, you have to consent to the forum.
China is geography and the West is strategy, right? So there's a lot of truth in that. You have to handle this very carefully, and that's why ASEAN is so important in the context of mediating with the whole region as a whole, all the 10 countries together, and then using that unity, bring other big powers into play so that we can balance them off against each other.
So small countries who continue to rely on international law for their very existence worry that there's no effective enforcement of the law. So that brings into question the very purpose of the international legal system. What laws should countries follow?
Both international law and domestic law depend on one factor that would make it an effective legal system, that is an impartial tribunal.
There is no supranational legislature, and that's why I talked about the two lawmaking forms, sort of customary international law or treaty-based international law. It's a diffuse system. We do not have an international sheriff, an international policeman, or anything else.
The legal framework that comes to mind are things like the United Nations Convention on the Law of the Sea. This kind of framework specifies the kind of territorial claims with regards to shelf boundaries and territorial waters. But the problem with legal framework like this, there isn't a central body that oversees its enforcement.
So international law are international agreements in general. If you think of them as international agreements, then agreements are renegotiated as conditions change and as new players come into play, come into the game. But if you call it law, then suddenly you're saying that somebody has broken the law and whatnot. And the other side might say, so what?